All right, welcome back. This is the second capsule for Wednesday of the third week, right? First time we have two capsules. We read more than one case for this session, right? More than one case for a specific session. And of course, the reason we look at it is because we have here an American perspective, or at least the state of the law on a specific issue that's very similar to what we see in the Cunningham case, which is the other case that we have to read for this week. So you'll recall, right, that the Supreme Court says that 15.2 obviously saves ameliorative programs, and that's good because it furthers substantive inequality, it furthers substantive equality, of course, right? The Supreme Court, you'll recall, also said very specifically there was a problem in the United States with these people not recognizing that, not recognizing the importance of substantive equality and having a narrower vision of formal equality, of everyone being treated the same and somehow anything deviating from that being discrimination. And obviously 15.2, according to the legislative intent of the legislators when they wrote it down in 1982, is to, right, move away from that vision. 15.2 confirms it because it says we allow programs that do, quote, reverse discrimination, right? That's what it might be challenged as, right? That treat a group differently in order to remedy historical disadvantage. You'll recall in the Cunningham case, the court's even more specific than that. The Supreme Court says very specifically, right, there was a problem in the United States when the charter was passed with programs being subject to challenge on that, to challenge based on that. It's something that we don't like, and therefore 15.2 is there to prevent that. Specifically, it's one of the cases where that happens, right? So it's v. Bollinger. What happens there, you have two Caucasian males who try to get admission into the University of Michigan, right, one of the top 10 colleges in the United States, undergraduate institutions, right, and they don't get admitted. And what do they say? It was discriminatory. Why is that? Because essentially the University of Michigan uses a grading system, right, for applicants. So everyone's attributed a certain score based on certain things, adds up to a total. And therefore, someone that's that's under the requisite threshold for that year is not going to gain admission. The University of Michigan recognizes that, right? Poorer people from more disadvantaged communities are significantly underrepresented in higher education. That remains true, right? There's something like as many people in American colleges from the top 8% of the population, right, kids of the top 8% of the population, as the bottom 92 combined. And the people who are from the bottom 20% of the population, you can basically count on, right, a couple hands. This is the most prestigious colleges, including the University of Michigan. The University of Michigan recognizes that, says we'll give non-Caucasian people 20 points in our score automatically. And so significantly, at least the United States Supreme Court there, right, there's no recognition of individual circumstances. So, of course, lots of people who are in that group might get a legitimate boost, right, a recognition of that. Someone who's historically been disadvantaged, right? Parents don't pay for, right, SAT tutors, right? The person faces various barriers in life, right? Has to work another job, has to, right, be in a smaller home with more noise, right? Harder to achieve the same thing as someone from a wealthier background, and oftentimes, as we know, right, race, wealth, and other factors are intimately intertwined, right? People who are from certain racial groups are disproportionately socioeconomically disadvantaged. University of Michigan says, right, we'll give them 20 points. Of course, for lots of people, it might be legitimate. That's really, right, where it gets to be a problem for the United States Supreme Court, right? Because we catch people for whom it is not remedying historical disadvantage, right? Some people for whom that 20 points does not reflect an actual barrier that they faced in their life. Basically, Supreme Court's concerned about, right, the African American child of a rich doctor. That person might have had the SAT tutor, not have faced barriers, and yet by virtue of the race alone, right, get a boost in the admissions process, and one in that case that is not legitimate. However, Supreme Court in the United States resort to very strong, right, remedy there by invalidating basically the entire procedure, saying it's discriminatory. Supreme Court of Canada arguably would not have reacted that way. Probably would have tried to, right, read something in, or in some way, right, try to adapt it for it to be fairer. Additionally, right, Supreme Court of Canada might have resorted to, right, either reading in within the provision or, right, reading down, as we call it, to exclude various groups, right? We'll see next week how these things play out, more particularly in the context of a Canadian Supreme Court case. Interestingly, however, right, Supreme Court says in some situations the University of Michigan would have been justified to have an admissions procedure that effectively engages in reverse discrimination, right? That effectively allows for the consideration of these barriers, and that is if it had what we call a holistic admissions process, right? If it had considered the specific barriers of individuals, not just added that 20 points to the score. That's because of the standard of strict scrutiny that you see applied in that case, right? Strict scrutiny says if you're trying to infringe upon, in that case, a 14th Amendment, right, in the United States, similarly to Canada, really, right? The various constitutional rights were added through amendments, right? In Canada, we added the Canadian Charter of Rights and Freedoms in 1982, which was much after the initial Constitution for Canada in 1867, right? The amendments there add the rights, and there's a standard of strict scrutiny there because there's infringement of the 14th Amendment, ostensible infringement. 14th Amendment said you're allowed to have equal protection of the laws, very similar wording to Canada, right? Canada says you're allowed to be free from discrimination under the law and also get equal protection of the law. So same language yields somewhat different results there, right? And standard of strict scrutiny applies because of that ostensible infringement, right? What happens when you do have that standard? Government has to show a compelling government interest, right? So in that case, combating discrimination or historical discrimination and enhancing the diversity of the student body. It's the compelling interest, and the government has to show that, right? The means it's using to achieve that goal is narrowly tailored to achieve that interest, right? Essentially minimal impairment. We see that also in Canada under Section 1, right? Which is where the same balancing happens, where the government explains why it's infringing upon constitutional rights, and the court, generally Supreme Court, says whether indeed the government is allowed to infringe upon a constitutional right. One of the standards has to be minimally impairing. It's basically the same as narrowly tailored, right? When we limit people's constitutional rights, we expect the government to have a compelling interest, but we also expect the government to make sure that it is achieving that interest, right, pursuing that interest in a way that minimally impairs constitutional rights because they're important. And in that case, right, adding the 20 points indiscriminately to everyone's files is not narrowly tailored, even though it's a compelling government interest. Interestingly, as I said, though, the wording of the provision is the same. Obviously, the 14th Amendment was adopted some 100 years before, and so, right, court didn't have an opportunity very early on, as it did in Canada, to highlight how it's supposed to further substantive equality. And so in Canada, we don't necessarily have the political divide in the conception of equality, because the Supreme Court made clear very early on that substantive equality is what we look at, and therefore that debate was never really made, because the Supreme Court had, right, tied its hands very early on, arguably for very good reasons. You have some pretty interesting standing issues, of course not particularly important for our purposes, but interestingly, right, the Supreme Court might be ignoring some pretty glaring standing issues, especially having to do with the injunctive relief, to achieve the goal of what it's trying to do there, right? So, yeah, similarly as in Canada, you have to have a reason to be in court, right? So you can't say someone's infringing upon my neighbor's constitutional rights, and you can't say someone's going to infringe upon my constitutional rights very soon, right? Or sometime in the future. Very soon might work, but sometime later on in the future might not, right? You have to have an impending or generally an actual infringement of your constitutional rights. Otherwise, you can't go to court, because courts don't just say what their policy preferences are, and also courts don't just strike down laws based on whether they're constitutional or not, right? Someone has to come in within that framework, right, with a reason to come in and say, my constitutional rights have indeed been infringed. And here there's a similar standing issue. You might argue that the majority of the Supreme Court, right, again, the vast majority of the judges, I think 7 out of 9, might very well ignore that for reasons of their own that might go beyond the case, or that might go to the precedential value that they want the case to have for one reason or another. And interestingly, right, that might well be why the case was picked in the first place, right? So quite similarly to Canada, there's a leave process in the United States. You'll recall in Canada, you have to get leave to appeal to the Supreme Court. So if you lose the Superior Court, first instance court, you're allowed by law to go to the Court of Appeal and say that was wrong, right? It doesn't mean the Court of Appeal is going to do it over, but it means that you have a right to argue that there was an error, and based on some standard that might be deferential or not, the judge here is going to look at whether indeed the court got it wrong. However, you don't have that same legal right to go to the Supreme Court. You have to have permission to go to the Supreme Court. This is what we call leave. Supreme Court picks the case. If not, you don't have a right to be there. Similarly, in the United States, your certiorari, you have to ask for permission to go to the Supreme Court. The Supreme Court has to pick your case. You might argue that the Supreme Court there picked a case that's obvious, right? That's obviously discriminatory, at least to 7 out of 9 judges, including some who are left-leaning, you might say, right? These political divides are far more relevant in the United States than they are in Canada. To have that, right, easier time making a decision that has broader precedential value, including in cases that might not be as obvious or similar to that one. I just want to take you, and we will definitely close on this, but I just want to take you to some interesting statements that are made in the dissent by Justice Ginsburg. Justice Ginsburg says first, right, this is not, right, the way to go, because there's significant underrepresentation of these various groups in higher education, as I said. It's factual, right? There's significant underrepresentation of people at the lower end of the socioeconomic background, gross overrepresentation at the other end, right? And she says, right, very strong language there, right? We are far distant from an overtly discriminatory past. And the effects of centuries of law-sanctioned inequality remain painfully evident in our communities and schools, right? The sense here that the law is not neutral, in the same way as we look at it in critical race theory, right? The law isn't just a thing that says what's legal or not. The law preserves existing dynamics of power, prevents people from having access to power, and creates distinction between people as to how much they're worth, according to the law, and subsequently according to various aspects of society that the law has an impact on. It refers indirectly, but very clearly as well, to slavery, right? In the wake of a system of racial caste only recently ended, large disparities ensure. And then she cites a bunch of things, again, for precedential value, because had she been in the majority, these things would all have been true pursuant to Supreme Court precedent, right? With a bunch of footnotes there, page 299. Unemployment, poverty, and access to healthcare vary disproportionately by race. Neighborhoods and schools remain racially divided, so on and so forth. Interestingly, how she justifies this, right? How does she justify, whether she believes that to be a compelling argument or not might be a different story, but how she justifies that 20 points, she says, without that, right, schools might try to do it in hiding, right? Without recourse to such plans, institution may resort to camouflage. In other words, they might try to see if someone's Hispanic to advantage them by looking at whether they're on the Hispanic club or their name. And that might be even worse because it won't just, right, affect people who are Hispanic but not disadvantaged, right? It might also benefit people who are just not Hispanic at all and have a Hispanic sounding name, and that would be an even worse outcome according to Justice Ginsburg.